Can you answer why? Why is it not? Justice Kagan has laid out one of the essential problems here, which is that you're making a distinction between status and conduct. Okay, we see that. And you keep saying this is conduct. Can you explain why?
The actus reus element, that's exactly what was missing in Robinson, and that's what we have here. And that's why that law was so unique. It's a very peculiar...
So it seems to me that Robinson actually hurts you and not helps you in the following sense. It seems both cruel and unusual to punish people for acts that constitute basic human needs. So here, unlike in Robinson, where, you had at least the sort of disease state, drugs and the like, and potentially culpable acts that relate to that disease state, here we're talking about sleeping that is universal, that is a basic function. And so I guess what I don't understand is, in this circumstance, why that particular state is being considered conduct for the purpose of punishment.
Well, I think that just illustrates the line drawing problems, because if you look at biological necessities and what a person needs to do, the Ninth Circuit's decisions in this area would allow all sorts of behavior.
Can I give you a hypothetical? Okay, so suppose the relevant ordinance prohibited eating on public property rather than sleeping or camping. We're talking about eating. And the city, for very, rational reasons, has determined that when people eat outdoors, it creates problems with trash and rodents and the like, and so it bans eating in public places, and it punishes violators. Now, just as here, that seems generally fine, because most people have restaurants that they can go to, most people have houses that they can eat in, but some people don't have that option. They have to eat in public because they're unhoused and they can't afford to go to a restaurant. So is your argument, same result, no Eighth Amendment problem, no problem with the city banning eating in public, even though that's a public function, even though that's a human necessity that everyone engages in, and really what's happening is you're only punishing certain people who can't afford to do it privately?
Well, it sounds like I take for a moment that you're not saying that the law draws lines on any sort of irrational basis or any equal protection
issue. No, the city has a perfectly rational basis. When people eat in public, there's trash, there are rodents, there are problems. So the city says what we're going to do is we're going to say no eating in public. What I'm concerned about from your argument is the suggestion, you call it conduct, I appreciate that, but what we have happening in operation is that people who are able to afford doing this thing that's a basic human need privately are okay. They're not punished for it, but people who don't have any other option or opportunity except for to do it in public are the ones who are being targeted by this statute.
So two responses. First, I think the Eighth Amendment is the wrong way to look at it. Someone might have a due process challenge to a law like that if there is a deeply entrenched liberty
But punishment
interest.
is happening. In my hypothetical, people are going to jail because they're eating in public. So why is the Eighth Amendment not implicated?
In that case, you would have a defense under Oregon law, for example.